attorney Rekha Ramjit, a defense attorney. Thank you so much for being with us.
And thank you for having me. And first of all, let me say congratulations to all the national awardees. And secondly, that Trinidad and Tobago have, all our citizens have a good and reflective Republic Day today.
The fault is all yours, and I join with you in that. The fault is all yours that I am deprived of sleep this morning because you had me all the way into Canada, who are the ones who were looking recently at a decision from their Supreme Court that told them because of the backlog they need to, according to the Ontario Attorney General, he said we need to remove preliminary inquiries. Many attorneys across there said, no, that's not the case because what you're proposing does not indeed solve the problem of the backlog. So the Indictable Offences Bill or preliminary inquiries is what we're going to talk about this morning. Some argue that the motivation behind this, you are a defense attorney, some argue that the motivation behind this opposition is the elimination of preliminary inquiries is that attorneys will be deprived of a revenue source, and they say that is one of the reasons they are all up in arms against it. How do you respond to that criticism?
Well, first of all, let me say I also read and I took the time out to listen to the arguments and read the Hansard, all 177 pages of it, because, politicians tend to be long-winded. So I read all the arguments of it. And the first thing that
when an attorney tells you somebody's being long-winded, what?
Right.
Because reading some of those statutes, you go like, could you simplify this? Please go ahead.
So one of the things that I looked for, and let me say categorically that defense attorneys, if you have a matter going on for, let us say, 10 or 11 years, and you have to be in court every 2 or 3 months, and you have a fixed rate that you would have to charge the client, how can it be because of money? Because your time must be spent going into court every time that it's court. So that cannot be because of money at all. But first, let me say that I think it was at the second reading of the bill, and AG Faris Alwari would have presented, I expected him to say exactly what was the purpose of the removal of the preliminary inquiry or pre-trial procedure bill 2017. What are you doing? Why do we have to have this?
Let me stop you right there, and you will continue with that inquiry you had of the Attorney General. Once you explain to our listeners what is the purpose of a preliminary inquiry for those who don't know.
Okay, great. So every indictable offense in this country must be first be laid in the magistrate's court. After it's laid in the magistrate court, there's something called a preliminary inquiry. And that inquiry is to test whether or not the prosecution has sufficient evidence to found a prima facie case. And at that point, the sitting magistrate then commits the person for trial in the High Court. So really, it is a test of the evidence presented by the state, whether it is through a police prosecutor or a prosecutor from the DPP, on that particular charge to determine whether or not we have sufficient to go forward.
Is there any validity to those who say if the police look at it and go to the DPP, who is the legal brain on their side, the prosecutors generally come from the same side. If the DPP say, I have enough information to go, why do we now have to still go to a magistrate for finding out if there is in fact sufficient evidence?
And a defense attorney. Well, first of all, there have been several cases, and I myself have had the experience, where at the end of the preliminary inquiry, a no-case submission has been made and successfully upheld. That in itself tells you that the evidence that was presented at the magistrate court was not sufficient on which to commit. Not only that, in our country, a man is innocent until proven guilty. Yes? And so he has to have the opportunity for a defense from the moment that he is charged. You cannot wait until the DPP, who is the prosecutor, here's what you're asking. The prosecutor should determine whether or not he should be committed. How can that ever be? It is the prosecutor's agents, the police who have charged. So how could you come to any other conclusion?
Good enough.
Because here what? And there have been several malicious prosecution suits upheld in this country. I myself have done several successfully, which means that at the point that the person is charged, that the police officer who was charging did so maliciously, either out of negligence, either deliberately, either didn't read the law properly, or didn't present sufficient evidence. So you are now asking that the person who is being charged does not have that representation and leave it only in the hands of the police and the DPP or the DPP's representatives. How can that ever be fair?
Now that you've laid the foundation, of that, you're saying now the Attorney General came in with the bill and he never articulated to your satisfaction what?
How it is that this bill is going to reduce the length of time, because the whole argument for the removal of the preliminary inquiry is that it's going to reduce the length of time matters stay before the court. And he has not done so at all. And as a matter of fact, there are several loopholes in several sections, as far as I can see, that does not do anything about the time frame. Okay, so let's just go. I want people to understand that in this country, a preliminary inquiry may take up to 3 or 4 years in the magistrate's court. And if that person is committed, then it takes another 5 to 10 years before they get a trial. Now, that is a problem. There's no denying that justice delayed is justice denied. But to remove the preliminary inquiry stage, while that may be acceptable, you must replace it with something that ensures that the accused rights are not trodden over, that you ensure that you would not have matters where the DPP indicts before the High Court that ought not to be there.
Is there a role for justices of the peace here?
No, well, justices of the peace, they come in very early in the game. And that is, before you are charged, you may have justice of the peace doing the bail, etc. No, there's not a role there in this entire process.
In between the masters of the court, anybody who
can... Originally, when it was first raised, this issue of removal of the preliminary inquiry was first raised, there was the thought that masters, right, criminal masters, will then determine the sufficiency of the evidence at something called a sufficiency hearing, where the defense counsel will present, just as if it's in the magistrate court, and make a determination, say, listen, for these reasons, a no-case submission is supposed to be upheld on behalf of my client. That does not appear in this bill. What this bill seeks to do is take it from the stage of charging, put it by a process in the hands of the DPP for a period of at least 12 months to determine whether or not the person should be committed. So at the end of 12 months, if the job is being done properly, the DPP could then say, I'm not committing him. I don't have sufficient evidence. Now think about this. For 12 months, somebody may be in remand yard while the DPP makes a determination. And that is not the DPP in himself, as Mr. Gaspar. That is his representatives in court, for example, because the DPP is represented by the prosecutors in court. So one of the first areas that is of concern is that Section 14 of the Clause 14 of the Act, and I'm being very specific here, says wherever any charge has been brought against any person for an indictable offense, the police shall submit to the Director of Public Prosecution certain information, right? All that they need to, it's called a file or a docket, with all the information that you're going to rely on to prosecute. No. It doesn't say anything about a time frame. It doesn't say anything about what if the police doesn't do it? What if the police doesn't do it on time? Nothing, no sanctions whatsoever. So if I charge today, I'm a police officer, I charge today, and I do not submit A, B, C, and D to the DPP. First of all, there is no direction in the Act as to how long I should do that, whether I should take 3 months or 6 months or a year. So I could take 2 years. There's no sanctions if I don't. So if I'm overworked, and very often we go to court and we have an indictable matter and police officer cannot attend because he's on some other thing, some other investigation, he's at a murder site, whatever, right? So there's no sanction. So how are you going to enforce that? And during the time that the police officer has to present this evidence to the prosecutor, to the DPP, our guy is sitting there. Right? This cannot be fair. I know John Public in this country fed up with crime. I know that. And we all are. It's on our doorsteps, everybody's doorstep. But while that is so, you cannot prejudice the rights of anybody who's charged. Because in this country, and I've said it before on this show with you, Mr. Bishop, that I don't believe we have reached a stage of maturity that we can be truly independent when it comes to these things. And it is borne out by the fact that several cases brought before the High Court, malicious prosecutions are upheld and the state is made to pay. So I don't need to say any more on that. Then it goes on to clause 15. So clause 14, 15, and 16, if anybody is reading the bill, should be taken together.
In case you're just joining us, the voice you're hearing is that of Rekha, Ramjit, criminal defense attorney. We are dealing with the bill that's moving through the House right now, the preliminary inquiry elimination of.
No. When the DPP gets this, and remember there's no time frame for no, at least not in the statute, yes? When the DPP gets this information, the DPP has 3 months within which of receiving the documents, have to serve the accused or his attorney at law with the documents that he has collected, right, within 3 months. If he fails to do it within 3 months, he can go to the magistrate and ask for an extension of time of 1 month. Fine. What happens if he gets the extension, and that should only be in special circumstances, and he still doesn't serve you with it? There is no sanction. There is no sanction. The magistrate has very little role in this process, you know. The magistrate really is like a case management house where come and make your application for the extension of time. I grant it or I don't grant it, but I have no power to sanction you or your representatives if you don't do anything about it. So it goes on. What is the impact of that then? Yes, I mean, how are we going to ensure that justice is speeded up if there is no sanction when you break any of these rules that are laid down here?
You, like Senior Counsel Pam Elder, are both against this issue of the elimination of PI. Through your association, the Law Association, was that something given to the Attorney General for consideration in this bill before this bill came to the House?
I don't know.
Was there consultation?
No, right. I am unaware. Oh, yes. The Law Association did send out the bill and say, what are your comments on it? And that's it. But there was no consultation, as far as I know, with getting a group of practitioners in the criminal arena from North, South, Tobago, Central, for example, and having our views on it. So,
but was the Law Association's representation consistent with what you were representing this
morning? I have
morning?
no idea, because I don't know what other defense attorneys would have said to the Law Association. But I do know that the defense attorneys to whom I have spoken have very great concern about this. I know, for example, Senator Sophia Choate, who's a defense attorney and a very experienced one of that. Her position is that, having read the Hansard, that she cannot at all in good conscience support this bill.
Because what you're positing here this morning, the absence of any thing to replace or substitute or be a bridge for the PI is disturbing.
Yes.
I mean,
yes, it is. I mean, you have to, you see, a person must have the opportunity to present his case and determine whether or not there's a prima facie case. And if that is taken away, I'm not saying it shouldn't be taken away, you know. What I'm saying is something should replace it that is as effective. Yes?
And that suggestion would be?
Again, something like the master that it originally suggested, but there would have to be a proper procedure and ensure that masters have been appointed, etc. Now, if you were to remove the PI completely from the magistrate court and don't have that middle ground of a master, etc., having a sufficiency hearing, then all that you're doing is transferring the cases from the magistrate's court to the High Court.
Which means you're increasing now the backlog.
Well, exactly. But not only that. If it is 30% of the cases or 40% of the cases would have been dismissed in the magistrate court based on a no case submission, all those are going. Because I'm honestly not convinced that the DPP is going to say, well, no, this is I'm not going forward with this charge. Remember, In matters such as serious criminal offenses like murder, etc., the police officer doesn't charge unless the DPP sees the file, So here's what's happened. Mr. X is held for murder. Yes? The docket is put together. The investigating officer takes the docket and meets with the DPP 11 o'clock at night or whatever and says, sir, this is the evidence I have in support of the charge. The DPP then instructs the police officer to charge. Now tell me, is it at all likely that when that same file come up for the DPP to determine whether to indict or not, is he going to indict after he has given the instruction to charge? I don't see that likely at all. Now, not only that, as I said before, remember, I am innocent until proven guilty. And the essence of innocent until proven guilty is this, and you'll hear it in a court of law. It is the prosecution that must prove its case. The defendant has nothing to say. I don't have to defend myself. You have to prove that I've committed it. I may choose to defend myself. I may choose to tell you what my defense is. However, that is not a requirement. I can sit silent through the whole thing. But in this case, before a determination is made as to whether or not the person should be indicted, Clause 16 now, so I said 14, 15, and 16 ought to be read together. An accused person or his legal representative may, you don't have to, that may recognizes my right to silence within 3 months of being served. That's the statements that they would have served, that's the statements they would have collected from the police officer, etc. Or within such further period as a magistrate may on application permit. So the defense can now go and say, listen, I need some more time, just as the prosecution did, serve on the DPP. What he's serving? His defense, his witness statement, his documentary exhibits, any alibi notice, any physical exhibits, that goes into the care of the DPP. I mean, come on.
What obtains right now for the sharing of all evidence with the defense attorney from the DPP? What obtains right now?
Right. And this is one of the things that this act has ignored completely. We recently put into place the criminal procedure rules. Yes? And the criminal procedure rules tell you what disclosure has to be made to the defense attorney, what the defense attorney has to disclose. So, for example, from time immemorial, alibi notice is always disclosed, right? We tell you up front, listen, on that day, I was in so-and-so place, I have an alibi, this is his name, this is his address, you can go question him if you want, right? So that is done under the criminal procedure rules. And that criminal procedure rules has not been adopted by this act at all, nor has what pertains there included in this act. And I want to say something else. The criminal procedure rules is really like secondary legislation. It's not statute like this, right? So that at any point in time, during the course of a trial, you can say, well, the criminal procedure rules are secondary rules and they are not law as such. So you could not use it, any deficiency, to support your case. Very much like the judge's rule. We have something in this country called the judge's rules by which prosecutors have to operate and which police officers have to operate. In other words, it tells you what you must and mustn't do in taking statements, for example, from accused persons, right? And we rely on the judge's rule to determine whether or not there has been fairness in taking the statement. When you present as a defense attorney, right, you always have to recognize that judges' rules are not law, They are secondary rules. And so there's no requirement to adhere strictly. Let me restate that. There's no requirement for a judge to say, based on what has been breached in the judge's rule, this has been unfair. They can take it or they can leave it. And so, by creating this act and not adopting the criminal procedure rules, the same thing applies. That those rules are now almost redundant. Yes? It ought to have been adopted because lots of time and effort was spent in determining how the criminal procedure rules was one way of reducing the length of time that a trial takes in the High Court. Because what it does is says, this is all the things we have to do up front. As soon as that is done, does not engage too much court time because the attorneys go back to the office and they do it. And soon as that is done, we have a certificate of readiness. and we're ready to go, which would have reduced the amount of time from the time the matters went into the hands of the court from the causes stage.
Prominent attorneys like yourself are pointing out exactly what is the problem with the PI removal. Do you believe this, in fact, will pass the House?
Well, you see, unfortunately, I believe the legislative body that we have, our representatives, parliamentary representatives, do not vote on issue and do not vote on whether or not this is good or bad for the country. They vote on we against them. Right? And so I do not in my lifetime think I will see, for example, whoever's in government, in this case the PNM, a PNM representative in the House voting against their bill. Neither would I see a UNC representative voting for the bill. I wouldn't see that. So what we have to rely on are the senators. And do we have sufficient who are independent? So you have some PNM senators, and so we're really relying on the independent senators.
Those appointed by the president. Yes.
Right. And some people may say they're not all that independent, but we have to rely on the independent senators to make the difference. Right? And so if I have read some of the contributions of the independent senators, Sophia Choate, for example, and she's clearly against the bill. Right? And I think her as a senator, her contribution should be given a great deal of weight, primarily because she has practiced in the criminal arena. And so she has first-hand knowledge of what has to happen. Now, there's another aspect of this, and that is the entire procedure does not give you any opportunity to make a no-case submission.
At all.
It does not give you any opportunity to make a no-case submission.
I am surprised at that because in en route to easing up the backlog, no case submissions is something that will go before and decide whether in fact we're going to take this to the next level and save time. So that is a little disappointing.
Right. So after that, no, there's another section, Section 22, which many people have said is similar to the old Section 34, right? The cop-out section, as it were. What says Section 22.2 says where the Director of Public Prosecution does not prefer an indictment against an accused person within 12 months after the expiration of the period specified in Section 16 as the 3-month thing, or within such further period as a magistrate may on application may permit it to do so, right? What happens at that point? He ought to indict, yes? If he does not indict, what happens? It is not quite clear as to whether or not the magistrate now has the power to dismiss the matter for want of the DPP not indicting on time. What happens at that stage? It is not quite clear. He may go back to the magistrate and ask for an extension of time. You see, this is why I'm saying, when Mr. Alwari presented this bill, and he never said it, that it was to speed up the process. When he presented this bill and said that it was, all I'm looking at here does nothing to assist that. And that is my concern with this bill.
We are going to have to wait and see how that pans out. The defense attorney is Rekha Ramjit. She is also the leader of the ILP for full disclosure. Again, this morning, not in that capacity. We had a lot of the things that we always have to go to, but because time is just on the top of us, it was good enough that we got the clarity on the PI of the indictable bill. You said that you are depending on what comes out of the Senate to make a difference here.
In my opinion, yes.
Right. I can only thank you again for being here this morning, as I have every morning, wishing you, of course, the best for what we have, the 42nd year as a Republican country, because we had 41, so we're going into 42. I hope that you enjoy the rest of the day, and thank you so much. Black Stallion has got a birthday today. I'm sure you will join in wishing him
I do,
happy birthday.
Indeed. And you know he's a South boy, right?
Oh, Lord, you had to claim him. Oh, God. Now we're going to the geopolitics now.
He's a South boy, yes.
Rekha Ramjit, thank you so much for joining us.
And thank you for having me here. Pleasure as always.
It is always a pleasure to have you here.